The gentleman from Alexandria, Mr. Levine.
Mr. Speaker, will the gentleman yield for a question?
Will the gentleman yield?
I yield.
Gentleman yields.
Mr. Speaker, I would ask the gentleman whether under his bill the protective orders could be obtained ex parte, that is, without notice to the other party.
Mr. Speaker, I would answer the gentleman by saying that, of course, when you obtain a protective order, for it to have any legs, essentially any validity, you have to serve it on the respondent. So for the respondent to be able to get in trouble, for instance, for breaking the protective order, they have to have notice that the protective order exists. This doesn't have anything to do with the respondent. This has to do with the petitioner and their rights, given the crisis that they see that they're in, which has led them to visit the magistrate and tell the magistrate that they believe their life is in danger, and to secure that protective order. And upon the issuance of that protective order, they would be vested with this additional protection.
Mr. Speaker, will the gentleman yield again?
Will the gentleman yield?
I will yield again.
Gentleman yields again.
Mr. Speaker, I would ask the gentleman if this order would still be available under subsection B and C of his bill to obtain a concealed carry permit, even if the order has not been served under the respondent.
Again, Mr. Speaker, at the risk of repeating myself, this has nothing to do with whether the respondent has been served. This has to do with whether the petitioner is in sufficient fear that he or she, in more likelihood, she feels that she's in danger of death or bodily injury, and she has gone to pursue this remedy as a way of protecting herself. It gives her the additional ability to protect herself discreetly with a firearm.
Speaker, speaking to the bill.
Gentleman has the floor.
Mr. Speaker, ladies and gentlemen of the House, I certainly understand what the gentleman from Shenandoah is trying to do here. No one wants to protect victims of domestic violence more than I. But one of the things that the people tell me who practice in this area is that increasingly the abusers are seeking to muck with the system, are seeking to seek protective orders. Under this legislation, as you heard the gentleman from Shenandoah say, someone can go in ex parte without notice. Let's say it's the abuser who goes in. Goes in ex parte without notice to the woman that he's beating up, can get a protective order. And furthermore, and this is very interesting, doesn't have to mention anything about firearms, doesn't even have to mention it to the judge. The judge issues the protective order. And then, even if it's prohibited under federal law, because it's a ministerial act by the clerk simply sees the order, and the guy can now concealed carry and can do a lot of damage. The governor last year proposed an alternative that would give the judge discretion, would allow the judge to consider. Maybe this guy has a long history of felonies. Maybe he's got domestic orders violence against him in Idaho, and they need time to check it out. This removes the judge's discretion and basically allows the concealed carry for someone who probably shouldn't have it. I should also note that guns are not the answer in these domestic violence situations. Studies show that a gun in the home increases the risk of death by 500%. That's 5 times. And part of the reason, I think, is that people, particularly women in these situations, are less likely to use guns against someone they love than against a stranger. So unfortunately, they're often used against themselves. Mr. Speaker, I would say that the governor's answer last year was the right answer to this problem, and I urge people to vote no in this bill. Thank you, Mr. Speaker.